All right. Good morning, good afternoon, and good evening, depending on when are you listening to this recording. Okay. So, as promised, I am recording a session for you, so that we can finish up the remaining topics in the sale of goods. Okay. These all are also important parts of sale of goods, a law on sale of goods. It's just that we were being deprived of the first week. Okay, so we couldn't finish it by or before the mid-sem break. Okay, so I'm now recording this to make up what uh, we didn't have. Okay, the first week. Right. So last week we have looked at the passing of property, okay, and I told you that property in goods is basically referring to the ownership of goods, okay, and there is another concept which you might be or which you might find confusing, is the even more important concept of title, okay, transfer of title or passing of title, okay. Here, both property and title, they are actually referring to ownership. But as you will see, for a property, okay, property in goods, it is between the seller and the buyer. Okay, but for title, it is between the buyer and other parties. Okay, especially when the buyer resells the goods to third parties. Okay, then we'll say whether the buyer will be able to pass a good title to the third party or not. Okay, we won't say whether the buyer would be able to pass a good property to the third party or not. Okay, so this is basically what are the differences. Okay, these are basically the differences between these two concepts. Okay, and the concept of title, okay, is very important in a sale. Okay, and under this subtopic, there is one important concept. Okay, the concept of nemo det. Okay, nemo det quote non habet. Okay, which means that no one can give what he has not got. Okay, so in short, it is called the maxim of nemo dat, or the concept of nemo dat. Okay, no one can give what he has not got. So the simplest example is the sale of product as a result of theft. Okay, if the product or if the goods is a stolen goods, then that will never be a good sale, because the thief will not be able to pass a good title, because that object which he stole does not belong to him, so he cannot give what he has not got. Okay, so the sale of a product as a result of theft will never be a good sale. This is simply because the product is obtained by way of theft. Okay, so the thief who steals the goods and sells the goods to a third party cannot pass a good title. And this maxim is partially embodied in Section 27 of our Sale of Goods Act. Okay, where it says that in subsection 1, it says subject to this act and any of other law for the time being, in force where goods are sold by a person who is not the owner thereof and who does not sell them under the authority or with the consent of the owner, the buyer acquires no better title to the goods than the seller had, unless the owner of the goods is by his conduct precluded from denying the seller's authority to sell. So, if goods are bought from a person who is not the owner and that person does not sell them under the owner's authority, the buyer does not acquire a title, even though he is a bona fide purchaser with value. Okay, bona fide purchaser with value means that he has paid sufficient consideration for the sale and purchase, and that is done in good faith. That means he did not know that that is a stolen good. Okay, and he has paid enough money. How he has paid for the price offered by the seller. Okay, and of course you have to take note here that it is not a problem even if the seller is not the owner, because there are occasions, in fact there are many occasions when the seller is not actually the owner. Okay, but this is not a problem because the seller who is not the owner could be an agent or someone who is authorized by the owner to sell the goods. Okay, so to be accurate, it is sold by someone without the authority to sell. Okay, so this is the general rule that no one can give what he has not got, and the object or the purpose of this general rule is to protect the right of ownership. Okay, so that, for example, if goods are stolen and subsequently sold to someone else, the right of the original owner is protected. Okay, the right of the original owner is retained. Okay, so in the case of Bishopgate Motor Finance Corporation Limited and Transport Bricks Limited, in this case, Lord Denning stated that in the development of our law, two principles have striven for mastery. The first is for the protection of property. No one can give a better title than he himself possesses. Okay, so that's why, going back to the example of stolen property or stolen goods, the thief does not have any title over the goods. So he cannot give what he has not got, or in the words of Lord Denning, he cannot give a better title than he himself possesses. He possesses zero. He possesses nothing. So he can give nothing. Okay? And then the second is for the protection of commercial transactions. The person who takes in good faith and for value without notice should get a better title. Okay, but it is the first principle that talks about the concept of nemo dat. Okay, and then in the Malaysian case, okay, of Sia Hyong Tee and others against Chong Soo Kong, where the federal court adopted the case of Bishopgate Motor and stated that the nemo dat rule is sometimes called the derivation principle. Okay, the transferee's rights derive from those of the transferor. The nemo dat rule protects the true owner of the goods, and the innocent purchaser who purchases the goods from non-owner gets no title, as the non-owner could not pass good title because he has none. Okay, so in other words, the right of the true owner is retained in the event of his possession is being stolen or sold to the unsuspecting purchaser. Okay, and then the case of Lim Chu Lai and Zeno Limited. So in this case, Zeno Limited, they entered into a contract with a contractor named Ahmad. Okay, and this Ahmad had contracts with the Petaling Jaya Authority for construction of culverts. Okay. Then the contract between Zeno and Ahmad was for Zeno to provide Ahmad with all the construction materials of culverts. Okay, and then Zeno Limited had bought and delivered the materials to the construction site. But Ahmad's contract with the Petaling Jaya Authority were cancelled. Then Zeno Limited told Petaling Jaya Authority that those materials on site belonged to Zeno. But when Zeno attempted to repossess the materials, it was found that Ahmad had sold the materials to the appellant here, Lim Chui Lai. Okay? So here, the federal court held that Ahmad was merely the bailee, okay, the person who was holding the goods on custody, okay, on behalf of someone else. So here, federal court said that Ahmad was merely the bailee and not the owner of the goods. Okay, when Ahmad sold the materials, the construction materials to Lim Chui Lai. This was simply because Ahmad had no title to the goods or authority to sell them. So it must then follow that Ahmad could not pass any title to Lim Chui Lai. Okay? So Ahmad did not have the title of the goods. So whatever he can pass, nothing. Okay, nothing he can pass to the appellant here, Lim Chui Lai. Then another case of Ngat Siang and Arab Malaysian Finance Berhad. Okay, here we have discussed about this case earlier, so I refer to that case, and you will find that there it also involved transfer without title, or in other words, that means the transferor had no title over the goods. Okay, so whenever he passed to the transferee, okay, to the next person or to a third party, there was no better title could be passed, okay, to the third party. Okay, so like I said earlier, the rule of, or the concept of nemo doubt is just a general rule. Okay, so it has been modified by the common law itself and by statute to meet the needs of the times. Okay, it is almost impossible to maintain this strict rule that you cannot pass what you have not got. Okay, so there are exceptions, okay, to this rule. You can refer to the case of Bishopgate Motor Finance Corporation and also Sia Hyong Ti, okay, where the court discussed about the existence of or the needs of exceptions. Okay, the court recognized the need for exceptions to take into account of commercial necessity and reality. Okay, and Section 27, like I said just now, contains the concept of nemo doubt, but at the same time, it also provides room for exceptions. Okay, if you look at Section 27, it starts with subject to this act and any other law for the time being in force. So the act itself also recognizes the need for exceptions. Okay, and the exceptions are found in various provisions in the Sale of Goods Act. Okay, so for the exceptions, we'll be looking at estoppel, sale by a mercantile agent, sale under avoidable aid contract, sale by want of joint owners, sale by a seller in possession, and sale by a buyer in possession. Okay, I believe that you have encountered this concept on or in different subjects. Okay, estoppel, particularly in contract. Okay, later on when you learn about equity and trust, you also encounter this concept again. Okay, so estoppel arises, okay, when the owner of the goods is by conduct precluding from denying the seller's authority to sell. Okay, that means you are prevented or you are stopped. Okay, you are stopped from denying something. Okay, so here estoppel arises when the owner of the goods is by conduct precluded from denying the seller's authority to sell. Okay, this is stated in section 27, subsection 1. Okay, 27, subsection 1, line 1, 2, 3, 4, 5. Yeah. Okay, line 5, where it says the owner of the goods is by his conduct precluded from denying the seller's authority to sell. This means that the owner of the goods, by his own conduct, make it appear to a buyer that the person who sells the goods has his authority to do so. Okay, and the buyer acts reliance on it. Okay, so that means there are three persons here, three parties or three persons, X, Y, and Z. Okay, so X is the owner of the goods. Okay, and Y is the person who sells the goods, and then Z is the buyer. So what is section 27 sub 1 is talking about, okay, particularly this part, is that X had done something, okay, and what X had done makes it appear to a buyer that Y, okay, Y, the person who sells the good, has the authority from X to sell the goods. Okay, and then because of this something, or because of the act that, or the conduct that X had committed, the buyer Z acted relying on it. Okay, so if anything happened, okay, in our context here, X is estopped. Okay, X is estopped from denying Y's authority to sell, because it is X who had done something, okay, which caused Z to believe, okay, this buyer to believe that Y is in fact a person who had the authority to sell. Okay, so when this happens, the general rule that no one can give what he has not got cannot apply, as the seller Y seems to be someone authorized by the owner to sell the goods. Okay, as a result, the owner X will be estopped from denying the seller's authority. Okay, this is because it is the owner's, okay, X's own conduct that creates the impression that the seller Y has the authority, and the buyer Z relies on the impression and buys the goods from the seller Y. So the buyer Y who buys the goods in good faith and for value is entitled to the title of the goods. Okay, so this is apparent as the court in Sia Hong Ti has recognized that one of the exceptions to nemo dat rule is when the innocent purchaser pleads estoppel by asserting that the statement and conducts of the true owner have led him to believe that the unauthorized seller in fact had the right to sell the goods. Okay? So we can look at the case of NZ Securities and Finance Limited for a real life example. So here, A agreed to sell a car to B. So A gave B possession of the car and B gave A a check as payment. Okay, and then B sold the car to C and took it back on a lease. However, before the sale to C was finalized, C contacted A's office, and in response to his inquiry, C was informed by A's employee that B had paid for the car. Later on, the check given by B was dishonored. Okay, so A repossessed the car. C sued A. Okay, then the court held in favor of C. A was precluded by its conduct from denying B's authority to sell. So the title had already passed to C. So in essence, it was because it appeared to C that B had the authority to sell. So then that authority came from A. So now A cannot come and claim for the car. Okay? So A is precluded from denying B's authority to sell. Okay? And the second case is Syarikat Batu Sinar Sdn Bhd. Okay? This is a very long case, but I'm not going to discuss it here. So I hope that you will have a look at this case because it talked about estoppel, and then it discussed the kinds of estoppel. Okay, and by looking at the facts, okay, how are these estoppel, or how could this estoppel arise? Okay, so please have a look at this case. Yeah. Okay, so and then the second exception is sale by a mercantile agent. Okay, or in general, sale by an agent. So under the general law of agency, an agent may pass a good title in selling the goods, okay, belonging to his principal, provided that he is acting within the scope of his actual authority. Okay. After this topic, when you come back from your break, we are going to look at the law of agency. Okay? Then you will know in details as to how agency works. Okay, but as for now, you need to know what you need to know is that an agent is someone who is authorized or who is empowered to do something on behalf of another person. Okay, and that person is the principal. Okay, so in an agency relationship, it is between an agent and a principal. Okay, so an agent may pass a good title in selling the goods belonging to his principal, but of course, this must happen with authority. Okay, or within the scope of his authority. Okay, so this, why we say that this is an exception to the rule of nemo dat, it is because the buyer has purchased goods from the agent and the agent is not the owner, but the buyer can still get the title lawfully and rightfully. Okay. But one thing that you have to be aware or you have to be careful is that the mere fact that an agent is entrusted with the goods or the documents of title does not of itself enable the agent to make a disposition, okay, binding on his principal. Okay, this means that while agent is generally authorized to act for and on behalf of his principal, the fact that he is holding, for example, the registration card, okay, or something that can prove ownership does not necessarily give him the authority to sell the property or goods. Okay, for example, if the agent is holding the registration card of his principal's car, okay, that does not mean that he is surely empowered or authorized to sell the car, but it could be due to the reason that the principal wanted the agent to safekeep the registration card, okay, but not for any other purposes, okay, but because of some bad intention on the part of the agent, he is trying to sell the car, okay, with the pretext or with the with the fact that he is holding the registration cards, so that he might be able to induce someone, okay, into believing that he has the authority to sell the car, okay, but that is not necessarily the case, okay, because it has to be for an agent, okay, to be able to sell the car or to sell the goods on behalf of the owner. There are conditions to be satisfied. Okay, it doesn't mean that you have the document of title, you have the registration card, means that you have the necessary authority. Okay, this is stated in the proviso to section 27. Okay, where you can see it says that provided that where a mercantile agent is with the consent of the owner in possession of the goods or of a document of title to the goods, any sale made by him when acting in the ordinary course of business of a mercantile agent shall be as valid as if he were expressly authorized by the owner of the goods to make the same, provided that the buyer acts in good faith and has not at the time of the contract of sale noticed that the seller has no authority to sell. So the very first condition is that the seller of the goods must be a mercantile agent. And who is a mercantile agent is defined by Section 2 of the Sale of Goods Act, where it says that a mercantile agent having in the customary course of business as such agent authority either to sell goods or to consign goods for the purpose of sale or to buy goods or to raise money on the security of goods. Okay, so to be a mercantile agent under the proviso to section 27, the person must have in the customary course of business as an agent the usual authority to sell goods or to consign them for sale or to buy them or raise money on their security. So if a person sells his own goods, then he will not come within this definition. Okay, and he will also not come within the proviso. Okay, because you must be an agent, okay, in the customary course of business as an agent with the usual authority. Similarly, a carrier, okay, a delivery man, a warehouse man, a bailee, they are also not mercantile agents because they do not normally have authority to sell goods entrusted to them. Okay, so if the delivery man of Ninja Van, he is not an agent. Okay, he is not an agent within the meaning of this section because he does not have the authority to sell goods entrusted to him. Okay, then the second element is that at the time of disposition, the mercantile agent must be in possession of the goods or the document of title of or the document of title to the goods. Okay. The phrase document of title is defined by section 2. In essence, it refers to an instrument by which the person putting it forward was entitled to dispose of the goods, and its objects must be disposition of the goods. Okay, so for example, for car is the registration card. Okay, so like I said earlier, having the fact that you have the document of title is not necessarily suggesting that you have the authority to sell, because it is just one of the many requirements that have to be fulfilled. And the possession, if you are possessing the goods, or if you are possessing a document of title to the goods, then the possession must be with the consent of the owner. Okay, and it must be given in the capacity of mercantile agent. Okay, and the consent, if the consent given is for sale, if the purpose of giving you for example the document of title, then there must also be consent, okay, to something of that kind, that is to sell the goods, okay, before the owner can be deprived of his goods. So giving you the document of title alone is not enough, or giving you the possession of the goods alone is not enough, but it must be given with the consent of the owner for you to sell it. Okay, and the fourth one is the dispositions. Okay, the third one here, as you can see in the case of Person and Rose and Young, it says that the owner must consent to the agent having them for a purpose which is in some way or other connected with his business as a mercantile agent. It may not actually be for sale, it may be for display or to get offers, or merely to put in his showroom. But there must be consent to something of that kind before the owner can be deprived of his goods. Okay? And then the fourth one is that the disposition must be made when acting in the ordinary course of business of a mercantile agent. So in the case of Oppenheimer, here a diamond dealer allowed another diamond dealer to take away some of his diamonds for the purpose of showing them to other firms for sale. Instead of doing that, the agent pledged, pajakkan the diamonds to borrow money. Okay, the court held that the lender obtained a good title, notwithstanding that the agent was not authorized to pledge them. Okay, because the agent was acting in the ordinary course of business. And in explaining what is meant by the agent acting in an ordinary course of business, the court said that the agent has acted in such a way that a mercantile agent would act within business hours at a proper place of business, and in other respects in the ordinary way in which a mercantile agent would act, so that there is nothing to lead the disponee to suppose that anything wrong is being done, or to give him notice that the disposition is one which the mercantile agent had no authority to make. Okay? And the last one is that the buyer must have acted in good faith without notice. Okay, that is to say, at the time of the contract, the buyer must have acted honestly and must not have notice or knowledge about the agent's lack of authority to sell. Okay, So in this situation, then the title will pass to the buyer with a good title. Okay. Then the third one is sale by one of joint owners. Okay. It is very usual that goods are jointly owned by several persons, so they are known as co-owners. Okay, for example, the construction materials used in a construction project may be jointly owned by the main contractors, subcontractors, as well as even the owner of the building under construction. Okay, so here there are several owners. So in normal circumstances, when one of the owners sells the goods jointly owned, he will pass the title over his shares in the goods only, but not the title over the whole of the goods. Okay, that means if you have let's say if you have if you are jointly holding or jointly owning 100 kilogram of bananas, okay, and there are 5 equal joint owners, okay, that means that each of them is holding 20% or 20 kilogram. Okay, so when you sell, when you as a joint owner, one of the joint owners, sell your shares, then you are only passing the 20% over the 100 kilogram of bananas. Okay, but not the 100%. Okay, because the 100%, the remaining 80% belongs to someone else. Okay, so that is the normal circumstance. But if the elements in section 28 are satisfied, then the sale by one of the owners of the goods jointly owned will pass the title over the whole goods to the buyer. Okay. The first one is that particular joint owner must have the sole possession of the goods by permission of other joint owners. Okay, meaning to say he is holding the goods all to himself. And secondly, at the time of a contract of sale, the buyer acts in good faith and has no notice that the seller lacks authority to sell. That means he did not know that that particular joint owner did not have the necessary authority to sell. Okay, otherwise he would be deemed to have had bad faith. Okay, with some hidden motive. Okay, in buying those goods. Okay, so there are these elements or these conditions to be fulfilled before the title over the goods can be passed by the by one of the joint owners. Okay, and then another one is sale under avoidable contract. Section 29 of the SOGA says that where the seller of goods has obtained possession thereof under a contract voidable under Section 19 or Section 20 of the Contracts Act, but the contract has not been rescinded at the time of the sale, the buyer acquires a good title to the goods provided he buys them in good faith and without notice of the seller's defect of title. Okay, Section 19 of the Contracts Act refers to voidable contracts caused by coercion, fraud, or misrepresentation, while Section 20 deals with undue influence. Okay, so reading Section 29 of the Sale of Goods Act together with Sections 19 and 20 of the Contracts Act, it means that the seller obtains possession of the goods from the true owner by a contract through coercion, fraud, misrepresentation, or undue influence. So by virtue of section 19 or 20, this contract is voidable. But before the contract becomes void, the seller sells the goods to the buyer. Okay, so according to section 29, if the buyer buys the goods in good faith and without notice of the seller's defect of title, then the buyer would acquire a good title to the goods. Okay. So, section 29 is to be read together with sections 19 and 20 of the Contracts Act. And as you can see in section 29, it says where the seller of goods has obtained possession. Okay, the word used in section 29 is possession. This suggests that possessions alone would be sufficient. It doesn't have to be property in goods that has been transferred from the seller to the buyer. Okay, so the innocent buyer would obtain title even though the seller has none but just the possession of the goods from the true owner under a voidable contract. Okay, so as long as the seller of the goods has obtained possession of the goods from the original seller, then the buyer would be able to acquire a good title over the goods. Okay, as long as he buys them in good faith and has no notice of the seller's defect of title. Okay, so there is an argument that this interpretation is dangerous because even a borrower of goods who has the possession of the goods may fraudulently transfer a good title to someone else. Okay, and the second last exception is sale by a seller in possession. Okay, section 30 sub 1 says that where a person having sold goods continues or is in possession of the goods or of the documents of title to the goods, the delivery or transfer by that person or by a mercantile agent acting for them of the goods or documents of title under any sale, pledge, or other disposition thereof to any person receiving the same in good faith and without notice of the previous sale shall have the same effect as if the person making the delivery of or transfer were expressly authorized by the owner of the goods to make the same. So the Privy Council had, in the case of Pacific Motor Auctions Proprietary Limited, stated the purpose of section 30 sub 1, that is to protect an innocent purchaser who is deceived by the vendor's physical possession of goods or documents and who is inevitably unaware of legal rights which fetter the apparent power to disburse. Okay, so what does section 30 sub 1 really mean? Okay, so section 30 sub 1 essentially covers this situation. Okay, a seller has sold the goods to the first buyer. Okay, the seller no longer has the title to the goods, but he still retains the possession of the goods or of the document of title to the goods. Okay, so if the seller sells the goods to the second buyer, this seller can pass a good title to the second buyer, provided that the second buyer acted in good faith and has no knowledge about the first sale. Okay, so here the cunning one or the dishonest one might be the seller. okay, because he has in fact sold the goods to the first buyer, okay, but because of the fact that he still has the possession of the goods or has the document of title to the goods, he is selling the goods to the second buyer, and the second buyer can obtain a good title from the seller provided that the second buyer acted in good faith and has no notice or no knowledge about the first sale. Okay, so but of course this would be unfair to the first buyer if he did nothing wrong. But just like other exceptions that we discussed earlier, the first buyer who were deprived of his rights will have his remedy against the seller. Okay, he can ask for compensation, can ask for damages, or can ask for the goods to be delivered. Okay, but the first buyer cannot claim against the second buyer, as he has the second buyer has got a good title passed to him, provided that he bought the goods in good faith and without knowledge. Okay, so to rely on section 30 sub 1, there are requirements to be satisfied. The first one is that the seller has actually sold the goods and title has also passed to the first buyer. Then after the sale, the seller continues to be in possession of the goods or the document of title to the goods. Okay, as you can see, I have given you two cases to explain what is meant by possession, okay, or continues to be in possession. Okay, in the Pacific Motor Auctions, it says that continues or is in possession means that the seller remaining in possession after sale, irrespective of capacity. So it does not matter if the seller is a bailey, agent, or what, as long as he has the goods in his possession. Okay, so this means that if there is a break in physical possession, then this provision will not be applicable. Okay, and then in Syarikat Batu Sina Sanjaran Berhad, which I ask you to read, also talks about this element where it says possession here means continuous physical possession without a break after the sale of goods and up to the time of another or subsequent sale. So if X has initially sold the goods and also passed the title of the goods to Y, but X has still retained the possession of the goods or the document of title of the goods. Okay, and all this while the goods or the document of title to the goods are with the seller, with X. Okay, then this would satisfy the second element. Okay, that the seller continues to be in possession of the goods or the document of title to the goods. Then the third element is that there is delivery or transfer of goods to the second buyer by the seller or by a mercantile agent acting for him. That is, actual or constructive possession of the goods is transferred to the second buyer. Okay, so there must be a delivery or transfer of goods. And the last one is that the second buyer receiving the goods should have done that in good faith and without notice of the previous sale. Okay, so let's say if X, the seller, has sold the goods and has passed the title of the goods to the first buyer Y. Okay, but the possession of the goods, but the goods or the document of title to the goods are with the seller X. Okay, and then Z, knowing that, and then comes and offer, let's say, hey, I give you a better price. Okay, then you sell the goods to me lah. Don't sell it to Y. Okay, then in this circumstance, this section would not be applicable because Z, as the second buyer, did not buy the goods in good faith. and he knew about the sale between X and Y, and he came to make a better offer. Okay, so there is an ulterior motive on the part of the second buyer. So element number 4 will not be able to will not be fulfilled. Okay. Then the last exception will be passing off title under a situation where the sale is made by a buyer in possession. Okay, that is provided for by section 30, subsection 2. So in this subsection, the first buyer buys or agrees to buy goods from the seller. Okay, with the consent of the seller, the first buyer has the goods or the document of title to the goods in his possession. Okay, and the goods in this transaction are subject to sale, pledge, or other disposition. But when the first buyer sells the goods to the second buyer, he can pass a good title or a clean title to the second buyer, disregarding those encumbrances. Okay, because earlier on I said that the goods are subject to sale, pledge, or other disposition, meaning to say there are encumbrances there. Okay, there are halangan on the title. But when the first buyer sells the goods to the second buyer, he can pass a clean title to the second buyer, disregarding those encumbrances. Okay, but of course, as usual, the second buyer must have acted in good faith and without knowledge or notice of those encumbrances. Okay, so an example can be seen from the case of Newtons of Wembley Limited and Williams. Okay, so here the plaintiffs sold the car to X, who paid by check, and the parties agreed that the title of the car would not pass until the check was honored. Nevertheless, X was given possession of the car. Later on, the check was dishonored. The plaintiff then rescinded the contract. But in between, while possessing the car, X had already sold the car to Y. Okay? Y was someone without knowledge of what had happened between the plaintiff and X. Okay? So after X sold the car to Y, Y sold the car to the defendant. Okay? Then since we say that X paid for the car using a check and the check was dishonored, okay, and before it found